removal defense, or that used to be called deportation defense, is the assertion by the person being deported that there might be a reason for them not to have to be deported. So removal and deportation are used interchangeably. They arbitrarily changed the name several years ago from deportation that everybody understood to removal that nobody understood. But that's what they did. And so as an example of how this works, removal cases are started by the filing of what's called a notice to appear by ICE in the immigration courts. Once that happens and they file the notice to appear, the removal proceedings are underway. The immigration judge is who decides whether or not to grant relief from removal or to enter an order of removal. In addition, there are appellate judges that hear appeals. And just last Monday, Trump tried to cut out all avenues of appeal from people who are appealing from denials by USCIS and ICE and EOIR. And so he tried to limit the appeals, and fortunately last Monday, U.S. Judge Randolph Moss blocked that. And so not only does the judge have jurisdiction over the removal case, but so too now do the appellate judges have jurisdiction over removal cases. A removal attorney does a lot for their client. For example, the attorney must get a very, very detailed statement from the alien to make sure that all avenues and issues have been covered. This often takes a very long period of time because there's a lot of information to gather in many removal cases. And aside from gathering evidence, the main thing about removal defense is the attorney arguing the case on behalf of the alien that they should be allowed to stay in the United States. Most judges are welcome applications for relief. It doesn't mean they're going to grant them, but it's just how the system works, and they expect to see applications for relief. And in fact, in many cases, when you're in immigration court, the judge will tell the client, the alien, what they're eligible for. And of course, judges have very, very broad experience, and oftentimes their perspectives really are critical to understanding what's going to happen and how to advise your client. Because if you understand what's going to happen, that's the only way you can advise your client about what's happening. And so judges look for detailed documentation of whatever the benefit is the respondent, that's the name of the person in removal proceedings, that the respondent has. The role of defense attorney cannot be overstated, cannot at all. For example, I had a case where I had 25 detainees, all of whom had final orders of removal, and a mistake had been made in the case, and the previous attorneys had done nothing to bring this to the attention of the court. For my 23 clients, because of errors committed by ICE, deliberate errors committed by ICE, even though they had final orders of removal, all 23 of the cases were reopened. And the immigration court judges around the country granted all but 2 of the applications for relief from removal. All of these detainees who had final orders of removal, almost all of them already have green cards and are on their way to citizenship. That's unheard of. And if it hadn't been for the Board of Immigration Appeals, who looked at this and remanded it because the government had deliberately outed my clients to USCIS, ICE, and EOIR. So there's really no difference at all between the 2 processes, and they're used interchangeably. I guess in a historical sense, if you're arguing cases before the change of the name, you could call it deportation. If you're arguing cases after the new name, then you argue removal, but it's all the same.